but on behalf of the faculty and Dean Salkin and the administration and all the students in Moot Court, I would like to welcome you here today to the 32nd Annual John Bainbridge Moot Court Competition. At this time, I would like to introduce Jason Prince, the Editor-in-Chief of the Moot Court Honors Board of Advocates.
Thank you, Professor Silverman, and good afternoon, everybody. Again, we apologize for the delay. I'll be brief in my remarks. Also, on behalf of the entire Moot Court Honors Board, I'd just like to welcome all of you to the final round of this year's, the 32nd Annual Bainbridge Moot Court Competition. Today, you're going to be hearing our two finalists, both second-year students, Jessica Semins and Gregory DeTolla. They will be presenting an oral argument before a panel of highly esteemed judges and attorneys who will be acting as if they are the United States Supreme Court. Both Jessica and Greg have worked extremely hard to get to this point today. Basically, a moot court is, for the first-year students who are here today, we are one of two credit-bearing honor societies at Touro. We travel the country, we compete against other law schools in appellate advocacy competitions. It involves research, writing, and obviously oral advocacy. It's a fun organization to be a part of, and each year, as a first-year student, you'll come into this room, or basically each year, first-year students come into this room not sure what to expect, and they leave this room kind of intimidated by the fact that the students up here, the students you're about to watch, are 2Ls. They're only a year ahead of you. And as intimidating as that might be, two of you most likely will be up here in the same position next year. So just watch, enjoy, and at this time, I'll introduce the problem, and then we'll proceed with the oral arguments. So this year's problem involves the issue of whether or not a state may forcibly medicate a mentally ill defendant in order to make them competent to be executed. Jessica will be arguing on behalf of the state, and Gregory will be arguing on behalf of the respondent, Scott Key. So at this time, again, thank you all again for waiting. We will proceed with the oral arguments.
Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States, are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court.
Please be seated, everyone. On behalf of all my colleagues, good afternoon and welcome. Are counsel here on the case of State of Touro versus Scott Key? Is counsel for the petitioner here? Good afternoon.
Good afternoon, Your Honors. May it please the court. My name is Jessica Semins, and I represent the petitioner, the State of Touro. At this time, petitioner would like to request 1 minute for rebuttal.
All right, you got it.
Thank you, Your Honors. Your Honors, this case is about ensuring that a violent murderer is properly medicated to guarantee that he can no longer harm another innocent victim. Accordingly, this court should reverse the decision of the Court of Appeals for two main reasons. First, Scott Key is eligible under Statute 1389 for involuntary medication. And secondly, Statute 1389 is not a violation of the U.S. Constitution. As to petitioner's first point, Scott Key is eligible under Statute 1389 for administration of medication because it is medically appropriate and it both furthers and is necessary to further Tourovia's interest in carrying out justice. The administration of Drug Plan 1 is medically appropriate because, as reflected in the record on page 2, Key has a mental illness that causes him to be a violent threat not only to himself but to others. This court held in Washington versus Harper that administration of medication, even though involuntary, is appropriate when an inmate is a dangerous threat to not only himself but to others. Furthermore,
Counsel, let me interrupt you for a second because I'm struggling with this argument from a policy perspective. So I think we can agree that drug 1 has a number of side effects such as nausea, diarrhea, etc. And you argue that the drug is nevertheless necessary for him to be medically competent. So take a different situation where we have an inmate who is diagnosed with cancer, and he's told he has 6 months to live, and you have a sentencing that's, say, 5 months away, 6 months away. Is it is the state's position that you can force this person to take chemotherapy drugs to put them into remission simply so that the state can extend his life in order to terminate the life?
Your Honor, the case at bar is quite distinguishable because in this present case, the inmate is dangerous. It is the state's primary obligation to ensure that a dangerous prisoner is properly medicated so that he cannot harm others.
But wouldn't that permit or even require the medication of any dangerous person simply to sedate them so they don't hurt themselves or others? It seems to me that argument may go a little too far.
Your Honor, Key does complain of several side effects as reflected in the record on page 4 associated with Drug Plan 1. However, it is the state's position that because those particular side effects are not in accordance with what the medical professionals have determined to be possible side effects of Drug Plan 1, it is the state's position that perhaps these side effects are merely the result of his living life on death row. This court held in Washington versus Harper that the highest deference must be given to medical professionals in determining which drug plan is most appropriate to administer to a particular inmate.
Excuse me, though, but in this particular case, the only time that we've seen this person in terms of being violent was when he was under the Plan 3, in this case, where he did exhibit some violent behavior. But other than that, in terms of the record before us, we have nothing but speculation by some doctors that say he could be violent. Is that correct?
Your Honor, it is reflected in the record on page 5 that while Key was administered Drug Plan 3 for only a period of 2 weeks, he erupted in a violent outburst which injured a prison guard. However, he also was violent as a result of his mental illness and committed a heinous murder of a young mother.
But I'm focusing now in terms of medication, the statute. He was under medication under doctor prescription for this plan, and even under this, he exhibited some violent behaviors. But other than that, either under Plan 1 or Plan 2, there was no any evidence of any violence. Am I correct?
Your Honor, it is correct that while Key was administered Drug Plan number 1, he did not exhibit any violent behaviors, as reflected in the record on page 4, which is precisely why the medical professionals, in accordance with what this court held in Washington versus Harper, have determined that Drug Plan 3 is not appropriate for him, and Drug Plan 1, because he was administered Drug Plan 1 for a sufficient time period of 9 months, during which he did not exhibit any violent outbursts.
So the purpose of him being found eligible is only to keep him competent, if you will, during the period prior to his actually sentence of execution. Am I correct?
Your Honor, it is the state's primary interest to ensure the safety. And this court held in Sell versus the United States that the safety issue of the state overrides the competency.
I understand that, but in this case, other than speculation on the part of some of these doctors and professionals, we don't have any evidence here of this person being violent while he has been in custody. Is that correct?
No, Your Honor. While he was administered Drug Plan 3...
Other than Plan 3, which you've already acknowledged and I acknowledge with you, other than that, any other evidence?
There is no other evidence reflected in the record that he was violent while under Drug Plan 1. Furthermore, Drug Plan 1 is necessary to further Tourovia's interest in carrying out justice precisely because the state has considered in implementing alternatives as this court required by the holding in Riggins versus Nevada. Drug Plan 3 was an alternative implemented at Key's request. However, because he became violent and injured a prison guard, medical professionals have determined it is not appropriate.
But the side effects, excuse me, of Drug Plan 1, a person who can't sleep, diarrhea, cannot do normal functioning behaviors under this Plan 1. Isn't that correct? The person is going to be debilitated and not being able to live a normal life, even in custody, while he's awaiting execution. And doesn't that also impact in terms of this person's ability to understand the consequences of what he's going through to be sentenced?
No, Your Honor. It is reflected in the record on page 4 that while Key was implemented the administration of Drug Plan 1, he was able to pass a competency exam. He has been supervised by medical professionals who have not noticed any of the symptoms that they have documented associated with Drug Plan 1, particularly in Key. Key actually complains of side effects of sleeplessness, while medical professionals, in accordance with what this court held in Washington versus Harper, to whom to give deference, have actually recorded that possible side effects are sleepiness.
Has he been administered Drug Plan 2?
No, Your Honor.
So we don't know the effects of that drug plan on this particular inmate, do we?
That is correct, Your Honor.
So we really can't say that other alternatives have been explored, have they?
Your Honor, it is true that Drug Plan 2 was not an alternative that was explored simply because Tourovia cannot afford Drug Plan 2, so it was not an option available. This court held in Washington versus Harper that the state is not required to set up and shoot down every conceivable alternative. In Harper, there was also a reasonableness test that this court held, and as a matter of reasonableness, Drug Plan number 2 is not an option that can possibly be implemented.
Is that based purely on the financial issue, or is there some other thing with the drug that's going to not make it work? Is it strictly financial?
Yes, Your Honor, it is strictly financial, and there are only 10 states currently in the Union that can afford Drug Plan 2. This court held in...
Counsel, let me ask you, you're citing Harper. So in Harper, we held that the Due Process Clause permits the state to treat a prison inmate with antipsychotic drugs against his will if the inmate is dangerous to himself or others and the treatment is in the inmate's medical interest, conjunctive requirement. Your argument here seems to add independent circumstances, that it's permissible where necessary to avoid incompetence so that you can carry out an execution. Is there any support for that position in our jurisprudence?
Your Honor, the answer lends itself to Petitioner's second point, that Statute 1389 is not a violation of the U.S. Constitution. This court must be assured that he has been afforded all of his due process rights in accordance with the U.S. Constitution. As this court held in Washington versus Harper, his substantive due process rights are carried out because he is a danger to others. Therefore, the medication is in accordance with his due process rights and alleviates the symptoms associated with his illness. Furthermore, his administrative due process rights are also carried out because this court held in Washington versus Harper that while he is under the supervision of medical professionals for a period of time, that sufficient time period can accomplish much more than could possibly be accomplished by a single judicial
Excuse me,
hearing.
let me just ask you this, following up on my brother's question to you. And that is that leaving aside what we've all just talked about in terms of the possibility of being dangerous to himself or to others, where, except under Plan 3, that's the only time it came up. So the question is that, are you asking us now, on a constitutional basis, to interpret the state statute to allow for involuntary medical treatment, even when there are no circumstances of safety to the inmate or to the others, and strictly on mental competency? Is that what you're asking us to do?
No, Your Honor. The state is not asking strictly for the reasons of competency. The state is requesting that involuntary medication be administered to Key in order to prevent him from being violent to others. Competency is merely a side effect of the medication. The Eighth Circuit held in Singleton versus Norris that the medical interests of a patient must be considered regardless of whether or not there is a pending date of execution. execution.
I want you to
How could
stay
it-
with, I'm sorry, go ahead, Judge.
Go right ahead. Go ahead.
Just staying with the idea of the medical appropriateness of the treatment and the perspective of the incarcerated person, the patient, do you see any disconnect between concluding that medication is medically appropriate and the consequence that the record presents that it will lead to his execution?
No, Your Honor, because his medical interests are being considered separate from whether or not there is a pending date of execution. This court held in Sell versus the United States that the short-term interests of a patient must be considered apart from whether there is a pending date of execution. It must be considered separate from his long-term interests. Furthermore, Statute 1389 is not a violation of the U.S. Constitution because it is a carefully drafted statute and was crafted, as reflected in the record on page 11, to be in accordance with the standards set forth by this court in Gregg versus Georgia. A carefully drafted statute, which this is comprised of 3 elements to ensure against the arbitrary and excessive infliction of a sentence, ensures that each particular inmate is guaranteed an individualized sentence, as this court required by Harmelin versus Michigan.
Let me ask you this, excuse me. Is your opinion that the issue of competency held to a higher standard once the person actually is facing the execution of death as opposed to a standard in terms of facing trial? Is the test more stringent for competency when a person is facing death?
Your Honor, and that is precisely why the elements of Statute 1389 are so stringent in order to be met. The Statute 1389 ensures that there is not an arbitrary and excessive infliction and ensures that there is an individualized sentence. Furthermore, this court also, Your Honor, I see my time has expired. May I please briefly conclude?
You can conclude your remark, and then you'll have a minute for rebuttal.
Yes, Your Honors. Furthermore, as a safeguard to ensure against arbitrary and excessive infliction, Touro enacted 1389 by its legislature, and he was sentenced by a jury of his peers and has not disputed either his sentence or the fact that he is competent, as reflected in the record on page 4. For the foregoing reasons, the petitioner respectfully requests that this court reverse the decision of the Court of Appeals. Thank you, Your Honors.
Thank you, counsel. Let's hear from counsel for the respondent. Please.
May I proceed, Your Honors?
Yes, you may.
Good afternoon, Your Honors. May it please the Court, my name is Greg DeTolla, counsel for the respondent, Scott Key. This case is about the extensive, inhumane punishment of a prisoner who is already suffering from mental illness. Accordingly, this Court should affirm the decision of the lower court for 2 reasons. First, Key is not eligible for Section 1389 because he does not meet 3 requirements under the statute. And second, the statute itself is unconstitutional because it violates the 8th Amendment.
Excuse me, counsel, let me stop you there for a second. Do you take issue with the legal issue that a person should be competent once he's been convicted and facing execution? Do you take issue with that issue?
Your Honor, the respondent does not take issue with the fact that a person should be competent for execution because in order to satisfy the goals of retribution, an individual must be competent and must understand the reasons for his punishment and for his sentencing.
Is there a powerful state interest in rendering him competent so that that retributive purpose of capital punishment can be fulfilled?
Your Honor, the state does have an interest in ensuring that the defendant is competent. However, in this particular case, the defendant is not rendered competent here. Because Key suffers from substantial side effects in a way that makes him actually incompetent for multiple days per week when his schizophrenic symptoms are actually made worse. Therefore, his schizophrenic symptoms are actually made worse. Therefore, he cannot be said to be actually competent. That that would be approved to ensure that he would actually understand the reasons for his sentencing. As to the respondent's first point, Key is not eligible for forced medication under Section 1389 because the 3 prongs under the statute are not satisfied. Pursuant to the first prong of the statute, forced medication under the Drug 1 plan is not medically appropriate. This court stated in Riggins v. Nevada that forced medication is generally not allowed when there are substantial side effects. According to page 4 of the record, Key's schizophrenic symptoms are actually made worse for multiple days per week.
Counsel, excuse me, are you taking issue with the fact that under no circumstances can there be forced medication, or only medication that is forced that still allows the inmate to enjoy some modicum of life pending the execution?
Your Honor, the respondent contends that Mr. Key does not want to be on the Drug 1 plan specifically. He is actually ready and willing to pursue other alternatives such as the Drug 2 plan and the Drug 3 plan.
But why should Tourovia have to provide the Drug 2 plan if it can't afford it?
Your Honor, pursuant to the third prong of the statute, forced medication is only necessary to further state interests when there are no other reasonable alternatives. The state is trying to put a price tag on Key's life that is apparently less than the additional cost of the Drug 2 plan. Furthermore, the Drug 3 plan is also another alternative that the state could have employed for a longer period of time.
What's the limiting principle? Is there there's no cost of a plan, no cost of Drug 2 that would render it out of bounds for us to order Tourovia to provide it?
Your Honor,
Where do we draw the line?
Your Honor, because of this court's holding in Harmelin v. Michigan, the court stated that the Constitution provides the utmost protection to those inmates who are on death row. This actually sets the bar higher for the state to take into account Key's liberty interests. To say that the Drug 2 plan is cost prohibitive is maybe a reasonable excuse not to use that particular drug. However, there are also other alternatives such as the Drug 3 plan. The Drug 3 plan was only implemented for 2 weeks according to page 4 of the record, and the state simply put him back on the Drug 1 plan without employing restraints or seclusion. These other alternatives could have been used and would have been not as intrusive to Key's liberty interest because he is ready and willing to use those alternatives in order to render him competent. He is not arguing against serving out his sentence or being executed. He simply just does not want to be on the Drug 1 plan because of the substantial side effects.
So the limit to the relief that he seeks is as you've just described?
Can you repeat the question?
The full extent of the relief that he seeks here is to be put on the Drug 2 or the Drug 3 plan, not more generally to question whether artificial competence as opposed to competence that does not require a drug plan is somehow a factor in his execution.
Your Honor, the answer to your question is actually pursuant to the respondent's second point, that this statute is unconstitutional because it is a violation of the 8th and 14th Amendments as applied to Key. On the Drug 1 plan, he is forced to endure significant side effects for an extended period of time before his actual execution. Therefore, he is arguing that forced medication under the Drug 1 plan is unconstitutional as well.
But counsel, if you were to take the plan 2, would it be your position that the statute does not violate the 8th Amendment?
Your Honor, if Mr. Key was on plan 2, this would not be a violation of the 8th Amendment because, according to page 4 of the record, the medical professionals have determined that this drug plan does work and does not have the same implications and side effects as Drug 1 plan.
So it's not a question of forced medication or not, it's a question of which medication and what side effects?
Yes, Your Honor.
And that determines the constitutionality of the statute?
Your Honor, as applied to Key, he is being forcibly medicated in order to render him competent for execution on the Drug 1 plan. And the respondent contends that that is unconstitutional.
And would it likewise be unconstitutional forcibly to medicate him on the Drug 2 plan? It sounds like you're saying no, that would not be unconstitutional. I just want to be sure I understand your argument.
Your Honor, forcibly medicating Key on the Drug 2 plan would not be as much of a punishment. Under this court's holding in Harmelin v. Michigan, punishments that differ from tradition or custom are often cruel and unusual. Because under the Drug 2 plan, he would not be subject to extensive side effects for an extended period of time, it would not be unconstitutional. However, that is not the case here. Here, Key is being forcibly medicated with drug plan 1 in order to render him competent for execution.
Counsel, so we know from the record that he's been diagnosed with schizophrenia. It causes delusions and paranoia. And the record also indicates that these symptoms can be managed, if not eliminated, through medication. Drug 1 is effective, albeit has side effects. Doesn't the state have a legitimate interest in administering drug 1, which is both affordable and does not have side effects that could put staff and other inmates at risk as compared to drug 3?
Your Honor, it is true that the state does have significant interest in maintaining the safety of its prison employees as well as the other inmates. However, this cannot be at the expense of Key's liberty interests. Because of the holding in Harmelin that states that the Constitution provides even more protection to those on death row, and because Key is being forcibly medicated, and because he is subject to extensive side effects, this is a significant intrusion into Key's liberty interests. Therefore, the state's interest in safety do not override Key's liberty interests. Furthermore, that particular sentiment comes from this court's holding in Washington versus Harper, which was not based on forced medication for execution. That particular defendant was an inmate who assaulted 2 nurses and was also not being medicated for execution. Therefore, his actual...
But hold on, let me just stop. So, but in Washington versus Harper, we recognize that prison officials, A, have an interest in ensuring the safety of staff and other prisoners, and B, a duty to take reasonable measures for the prisoner himself, his safety. Doesn't Torovia 1389 comport with these interests and duties?
Your Honor, Torovia 1389 does comport with those duties. However, in that particular case, that prisoner was not on death row, so he is not afforded the same protections of the Constitution that Mr. Key is afforded. Furthermore, Key's medication does not further state interest in carrying out justice because Mr. Key is not sufficiently competent.
Let me follow up on that last question. What is his liberty interest in this case?
Your Honor, Key's liberty interest is to be free from unwanted antipsychotic drugs. His liberty interest is highly intruded as per the holding in Riggins versus Nevada when there are particularly severe side effects.
And you are asking us to weigh that more heavily than the state's interest in ensuring that a person facing execution must be competent. Is that what you're asking us to do?
Yes, Your Honor. And on top of that fact, Key is actually not a danger to himself or others. The state is claiming that Key is a danger to himself because he committed a murder when there are many other prisoners within the prison who have committed murder as well. Furthermore, the only time he had a violent altercation was when he was on the drug 3 plan. The state did not even try to not medicate him, nor did they try to put him on the drug 2 plan or keep him on the drug 3 plan for an extended period of time and allow the antipsychotic medications to start to work.
Would it also be fair to say that the state's interest is in carrying out the sentence imposed by the trial court on this, and that is death because of this crime? Isn't that a legitimate state interest?
Yes, Your Honor, that is a legitimate state interest. However, the state cannot ignore Key's liberty interest in order to carry out their interests. Because Key is ready and willing to take these other alternatives, he is not arguing that he does not want his sentence to be carried out. He just does not want to be on the drug 1 plan.
So you think it would be medically appropriate to order Torovia to put him on Plan 2, correct?
Yes, Your Honor.
I'm having a tough time wrapping my head around the notion that it would be medically appropriate for your client when that course of action would make it much more likely that he would be executed.
Your Honor, the respondent is not arguing about being executed. He is willing to...
I get it, but that's why I'm still asking the question. You're asking us to do something that's medically appropriate for your client. I get it. But he's more likely to have his life terminated if we engage in that course of action than if we don't, near as I can tell. At least I want you to indulge that assumption. So why should we do that? Why should we go down a road that makes it more likely that the state will extinguish his life?
Your Honor, as to the respondent's second point, Key right now is being forced to endure significant side effects for an extended period of time. In fact, a minimum of 20 years. He would rather take a different drug plan where he was not subject to side effects that render him, that
Well,
make
that
him.
counsel's in favor of the Plan 2 instead of Plan 1. But why any plan at all if we're acting if you're asking us to act in the best interest medically of your client, why would either of these plans fit that description if it makes it more likely he'll be executed?
Your Honor, the state, while Key is asking that it doesn't want to be on the drug 1 plan, the state still does have an interest in carrying out justice. Therefore, the drug 2 plan would be in Key's best medical interest because he wouldn't have to suffer from the side effects.
Following up on Judge Gleason's point, I think if we were to conclude based on this record that a predictable side effect of the drug 2 plan is death, is that something we can take into account?
Your Honor, there are.
That puts sleepiness or sleeplessness in a whole different category.
Your Honor, while death would be a significant side effect, it is a side effect that occurs with several other antipsychotic drugs. In fact, many of them, according to the record.
Doesn't that make them all subject to the same tests and concerns and infirmities that you're asking us to endorse with respect to drug plan 1, that a big side effect is a reason why there are constitutional problems? I mean, death is a big side effect.
Yes, Your Honor. However, because Key is constantly flowing in and out of psychosis on the drug 1 plan, he does not want to be kept on that drug 1 plan. The fact that he is willing to take drug 2 and drug 3 plans means that those other plans are less intrusive. Furthermore, back to the respondent's second point, Harmelin versus Michigan stated that punishments that differ from tradition or custom are often cruel and unusual. Key's punishment differs from custom and tradition because he's required to undergo extensive pain and suffering before his sentence is even carried out. The state is taking away his life before they take his life. Furthermore, this court's holding in Gregg versus Georgia stated that the death penalty cannot be imposed in an arbitrary or capricious manner. Key's death sentence is imposed arbitrarily because the state has unlimited discretion. The medical professionals that the petitioner continuously relies upon are not challenged in any way when they determine Key's competency. He is entitled to a fair evidentiary hearing as required by this court's holding in Ford versus Wainwright and Gregg versus Georgia to determine his competency. This never occurred in this case. Mr. Key was not giving a fair evidentiary hearing, and there was no third-party psychiatrist brought in, and in addition, there was no psychiatrist brought in to offer testimony on Key's behalf.
Excuse me, there were findings, though, in the court below, am I correct? On competency, there were findings?
Yes, Your Honor. Key did pass a competency exam. However, this did not pass constitutional muster under the holdings of Ford versus Wainwright and Gregg versus Georgia because there were no third-party psychiatrists involved, and there were also no psychiatrists involved to offer testimony on Key's behalf. These were state psychiatrists that conducted this particular competency exam. Your Honor, I see my time is up. May I briefly conclude?
Yes, you may.
For the foregoing reasons, the respondent asked that this court affirm the decision of the Court of Appeals. Thank you.
Thank you, sir. All right. Petitioner's counsel has reserved a minute for rebuttal.
Your Honors, petitioner has 1 point to make on rebuttal. It is the respondent's contention that the state has not considered Key's liberty interests by not considering alternatives. However, not only did Key give up his liberty interests when he committed the heinous murder of a young mother, however, deference must be...
Wait a second. He has no liberty interests because he's been convicted of the murder?
No, Your Honor. However, he does not maintain the same interests as someone who is not being incarcerated.
But he has the same liberty interest of every single death row inmate, correct?
Yes, Your Honor, that is correct.
You don't give those up by committing the murder. You still have a liberty interest that's protectable by the Constitution?
Yes, Your Honor. His liberty interests are being protected by this court's holding in Washington versus Harper. His liberty interests are being protected because a panel of medical professionals have been entrusted with his... Your Honor, I see my time has expired. May I please...
You can finish the thought. Go right ahead.
Thank you, Your Honors. He is being supervised by a panel of medical professionals who have determined that because he is dangerous, it is appropriate to implement drug plan number 1 for the reasons of safety, primarily the reasons of safety. And the petitioner respectfully requests this court reverse the decision of the Court of Appeals. Thank you, Your Honors.
Thank you both. We'll take the petition under advisement. Please be seated, everyone.
So before we actually announce the results, I do want to thank everyone again for coming today, especially due to the delay, and also especially thank our judges. I also want to introduce the 4 of them. Our Chief Justice today, the Honorable John Gleeson, United States District Court Judge for the Eastern District of New York. We also have, for the 2nd year in a row, the Honorable Elizabeth Stong, the United States Bankruptcy Court Judge for the Eastern District of New York. We have the Suffolk County Bar Association President, Mr. William Ferris, and also the Nassau County Bar Association President, Mr. John McEntee. We also have a few gifts for our judges today as a sign of appreciation for their being here. Obviously, none of this would be possible without all of you generously donating your time today. So we really do appreciate that.
Yes, I'm in private practice. I can take swag, so it's...
And
Thank you.
before we do the results, we actually have some more swag. For one. Each year we give out an award in honor of Judge George C. Pratt. The reason we've honored the award after Judge Pratt is because he has consistently, and still to this day, makes outstanding contributions to the Moot Court Board. Typically it goes to one of our faculty advisors. They're always amazing. They were again this year. But this year we had someone who's not a faculty advisor who has helped us out tremendously, made outstanding contributions. And that person is Professor Samuel Levine. So I'd like to ask him to come down at this time. So at this time, I'll hand it over to Chief Justice Gleeson, and he will announce the results.
Great, thank you. Before I announce the winner, let me, on behalf of all of my colleagues, thank you for having us here for this Bainbridge competition. It's an honor to be asked to preside. Lesser judges would apologize for keeping you waiting for so long. Judge Stong and I got stuck in traffic, and we thought as we were doing it, their poor advocates, Jessica and Greg, it's like icing the kicker before the big kick, and so sorry about that. It contribute to the pressure, but we finally made it, and again, apologies for the delay. To cut to the chase, you know, these things, judges are fond of saying in these moot court competitions that the decision's very difficult and it could have gone either way. And sometimes that's true, sometimes it's less true. It was certainly true here, and my colleagues can speak for themselves, and they will in a moment, about how impressive both Jessica and Greg are, and no doubt will be in their long careers in the law. And we were back there for a little while because we had to discuss which one to decide to give the award to for best argument. And in a very close call, congratulations, Jessica. We've decided on you. Greg, certainly don't hang your head. You did a fabulous job. We all have a few brief comments. We won't keep you long. But let me turn to my colleagues, especially the colleagues who made this an especially hot bench, to provide a couple of points of pearls of wisdom. Why don't we start with Bill?
Thank you. Let me just repeat, and it sounds repetition, but it's true. It's very difficult to sit up here and really judge two really fine attorneys. attorneys to be to do this. I understand you're in your second year, and that's really commendable. To deal with the constitutional issues, also to deal with the record, and to really frame the issues, the factual basis, in order to argue for or against the statute on constitutional bases. And so my perspective really is that, because you need to know the court that you're going to. And I do think that you both did that extremely well. And Jessica, you certainly were tenacious in that. You stuck to your guns. And Greg, the same thing. It's just that sometimes you need to really, how should I say, stick with that argument. Don't let us distract you from that. Acknowledge something. If you don't agree with us, that's okay. That's why we're here, because we want to hear the positions and an argument. So don't, if you did that, you were very clear. You disagreed with something we said, and that's okay. But again, really great. It is an honor to be here, and I want to thank you for being asked to participate in this. Thank you very much.
Thank you, sir. Liz, Justice Stein.
Oh, please. It is terrific to be back. It's great to see people I remember from last year, and it says something about the intensity of the experience that I remember you. I remember the orals from last year. It's quite special, so bravo. And bravo to the two of you. It's a huge effort to undertake this. You're both terrific. You would be welcome in our court anytime. It would be a pleasure to have you. Don't forget that. I really mean it. It's a lot of fun for me to do this, not only to be back, not only because I'm a great admirer of your school and your students and your dean, but also because, look, I get to sit with two presidents and a district judge. That's very cool if you're a Article I bankruptcy judge. The energy in the room is palpable. I told you about it last year. I feel it again. I felt it when we walked in late. Being the lesser judge, I will apologize. But I was affirmed yesterday, however, by Judge Gleason's court, so that was a great pleasure. It was even in the law journal. The energy in the room is terrific, and it just confirms that you really are prepared, that you get it, that you know that you are each other's best friends and allies and resources at this school, in this profession, going forward now and forever. This profession is first and foremost about people, about your reputation, about the respect that you hold each other in, and the energy in the room. The fact that you are so here for your classmates is just tremendous, and you should give yourself a round of applause for that as well as them, and I really mean that. On to you guys. We make decisions for a living, and this was a hard one. You were both very good at responding to our questions. Something that bugs judges a lot is when the lawyer doesn't respond, and you both responded. Some of the questions lots of them were hard. Some were hard and awkward and went to the twist points, the inflection points in your arguments, and you stepped right up, and that was terrific. Jessica, I thought you did an especially good job of coming back to your themes. You had a story, you were about it, and you came back to it whenever there was an opportunity to work it in, and also on rebuttal, though Justice Gleason did, I think, appropriately remind you who your audience was. But you handled that really well, too, and I hope I would have handled as tough a question from as great a judge as Judge Gleason. So again, bravo on that. Greg, in a way, you had the appealing argument here, and that can be a harder situation to be in, and I thought you handled that very well, too. Not saying, look, this is an awful thing, but here's the law, here's our objective. So I pressed you about what are you trying to accomplish here. Here is our client's goal. It's a specific and a limited goal. Sometimes the policy speech you might want to make in the town square is a very different kind of argument than the presentation you make from the podium, and I thought your argument really reflected appreciating that difference, and I was impressed by that. So bravo to both of you and to all of you. Thank you for having me.
Thank you, Liz. John?
During my career, I've argued, a few dozen appeals, not an enormous amount, but what happens is when you go to argue an appeal, oftentimes there'll be 10 appeals ahead of you. And so as a result, I've watched at least probably a few hundred appeals. And what always amazes me is the wide range of abilities. You have people that are really good, you have people who are really bad. and it's a range. And what I can say is what I saw here today was at the high end of the range for admitted attorneys. I thought both of you handled yourselves very well. Neither one of you got rattled when you were asked questions. You stuck to your theme, your theory of the case. You were both knowledgeable about the record. You're both knowledgeable at the case law. You're able to cite the case law. And you represented your schools wonderfully. You know, this reflects so well on the school here that, you know, two, I think, second-year students can be so articulate and argue a case so well. The one thing I remember from law school is somebody said to me, the way a young lawyer can match up to an older, experienced lawyer is through preparation. Okay, because sometimes you'll see lawyers just wing things as they get more comfortable. And you can see the value here of preparation. Both of you knew the record cold, you knew the case law, and that showed in the wonderful presentations you had. So I thank you so much for having the benefit of being able to come here and see such a wonderful argument. So I'm grateful. Thank you.
Thank you, sir. And there's no reason for you to appreciate just how right John is about how you already stack up against everyday practitioners. You know, unfortunately, the quality of advocacy out there isn't what it ought to be. You guys are good. You're good already. Don't get too confident about it because, you know, the reason you're good is you're prepared and you need to always have that edge. Jessica, I thought you did a fabulous job of making sure the argument proceeded on your terms. We always stayed we're at your lines of scrimmage, and that's it's a very valuable asset to have as an advocate. I too was a trial lawyer and an appellate lawyer, and you act differently when there's not a jury in the room. That's why I hung you up on your rebuttal. You know, and a jury's in the room, you can get away with saying things like, well, he had a liberty interest until he shot the victim. You know, jurors like that. But this is an appellate court, which is not interested in having its passions inflamed. So you're always going to get your chain jerked a little bit when you try to do something that looks like a jury argument to a bunch of appellate judges. I thought you did a fabulous job, Greg, of isolating your client's case. You know, you got questions that placed in clear relief the importance that this is a death row case. You carved a path for your client that made it clear that if this court was going to entertain a constitutional challenge to the entire statute, we're going to need some other respondent besides your client. So you isolated where you wanted to go. I thought you did a pretty good job of sticking to that. This notion of, you know, we're slaves to process. It's our middle name is the process. So this notion of having been deprived of a hearing as kind of a real linchpin to your argument is always attractive to an appellate court. So I won't keep you any longer except to say once again, congratulations to you both. You just did a fabulous job. I'm so impressed at how many people are here. Others have mentioned this, the degree of enthusiasm and interest in it. It's so important. It's so important to you and to the two folks who are arguing that you demonstrate this level of interest. This is important. You guys, you know, you're the future, and the law, using the law to affect positive change, whether it's just in the life of your client or in the life of the community, that's what you're going to be doing. And this is how you learn how to do it. And I'm so impressed that so many of you are here to support Jessica and Greg and to just to be witness to all this. So I think, unless someone tells me it's not the right time to declare these proceedings to be in recess, I think that's my job, is to congratulate Jessica and Greg one more time and to declare this proceeding of the Supreme Court of Tourovia to be in recess.
Sign it.